Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association's Antitrust Law section. My name's John Roberti. I'll be your host today. And today's topic is, so what's the loss? An economist's take on private competition litigation outside the U.S. Today we're going to be talking about the use of economic and statistical analysis in recent private competition litigation cases in the UK and beyond, including in follow-on claims for damages, in cartels, and claims for loss as a result of abuse of dominance or monopolization. In the U.S., we're very familiar with private damages litigation, but in Europe, and it's a relatively new phenomenon. The UK, I think, is more advanced than many of the other European countries, and I think it's interesting to get a perspective from the UK and maybe from Europe more broadly about where things are going and maybe where some of the differences between the U.S. and the UK, Europe, where all of those things are going to end up. My co-host today is a EU and UK competition lawyer at the Maguire Woods law firm in London. He's lived in London and worked in Brussels, which is the EU's effective capital, for nearly 18 years. Hi, Matthew Hall.
Hi, John. Thank you for that introduction. It's as you say, these private antitrust litigation cases are very important now in the EU and elsewhere. And it's pretty much standard in the EU for any cartel decision to be followed by a private damages claim, but there are also a lot of standalone claims where there was no regulatory decision at all. In addition to the UK, I think we're really looking at Germany and the Netherlands in the EU as the key jurisdictions. And I think that companies looking at this on a high level really need to consider competition litigation as part of their standard toolbox to defend their interests, whether you're also on the claimant side.
Matthew, I think that's 100% right. As I said before, we have a lot of experience with this in the U.S., and I think corporations in the U.S. are used to the idea that there'll be private litigation. It's a part of doing business. I think what elevates the importance of private damages litigation in Europe these days is that it also has an interplay with leniency. We talked a little bit about that in one of our earlier podcasts about whether leniency is really dead. But one of the things we talked about was, is private damages litigation really outstripping it? And I think it's really, really critical for us to try to get our arms around what's going on with this private damages litigation.
Yes, you're right. The issue is also important here. Is the success of the leniency program at the EU and national levels killing off private litigation, or at least making companies wary of using leniency because of the risk of private litigation? I think we'll talk with Matt about his experiences, but it's clear to me that it is continuing to expand as an area in the UK and elsewhere in the EU. And I don't see that stopping, not least because standalone cases are beginning to come in any event.
Well, Matthew, who is our guest today?
Well, we have Matt Hughes, who is an economist and partner at AlixPartners in London. He's a professional economist. He started his career at the UK Office of Fair Trading, now the CMA, or Competition and Markets Authority, which, as you know, is the UK's main competition and consumer law regulator. He's worked on many private competition or antitrust claims in the EU, the US, and elsewhere, both on the claimant and defense side. So as an economist, of course, his main role in those cases is trying to demonstrate loss or show that there was no loss. So we've had the pleasure of working together on some cases on opposite sides where we had a disagreement on those issues, but that's always the case, isn't it?
It certainly is, and it's one of the great things about our bar is we find ourselves on the same side and on different sides, and we remain friends at the end. Well, what are we hoping to get out of the conversation today?
Well, as I said, John, Matt's an economist, so we're going to be talking about the economics of these cases, in particular loss calculation, and what parties should think about when they get into these issues, both here in the UK and more widely around the world. So I think there are a lot of lessons which Matt's experience can be useful to talk about.
Well, super. Let's bring in our guest. Matt, welcome to the program.
Thank you very much.
Hi, Matt. Thank you for joining us. So we've given our introduction. I just wanted to ask you, as an economist sitting there here in London, what is the big picture in terms of competition litigation claims that you're seeing here in the UK and around the world?
So perhaps the first thing I should say is that just to put some of this in perspective, in terms of numbers of claims and what's going on, is that most claims are settled privately without being fully litigated in Europe. So if you were to look at the European Commission's 26 cartel decisions from over a 5-year period from 2014 to 18, we, AlixPartners, and including me, have worked as independent experts with claimants or defendants on 10 of these cases. All of these were settled out of courts, and I know that there was litigation on a further 2 cases, namely power cables and euro interest rate derivatives. There has only ever been 1 case in the UK that's been fully litigated, which was the Britned case, with that case relating to power cables. So the key message at the outset is that most of this doesn't occur in the public eye. Most of this occurs in the context of private settlement.
So there's a lot that's hidden there. There's a lot of what we see in the public domain in terms of reported cases it's a bit like a duck. There's a lot of paddling underwater there.
Absolutely, and you simply don't see it. And this is a very large part of what we as a firm do for a living. And whilst I'd like to believe we have a 100% market share, the fact that we've worked on 10 out of those 26 cases does rather suggest to me that almost all cases are litigated, except where the market affected is very small.
Yeah, that's my experience. I mean, a lot of these cases, as you say, are settled, or indeed are a try-on in many cases as well. But as an economist, Matt, so stepping back, what's your broad role on these cases? When do you come in, and how do you divide between? How does it divide between you and the lawyers? Okay.
So my perspective on these cases is that cartel cases, from an economist's perspective, are fundamentally about facts. And to get those facts, you often need to do a lot of hard work, and particularly need to be able to extract the data relating to sales, prices, product features. You often need to do legal and data archaeology, because a lot of the facts and material that you need is on multiple IT systems. A lot of cartels happened or started many years ago, so often you need to think about getting data off legacy systems. You also need to know a lot of technical and market information about products, costs, what affects demand. And the reason why you need such a range of information is because if you want to understand what the effects of the cartel did to prices, you need to know what else was affecting prices. What we in essence... Sure.
I'm sorry, Matt. I didn't interrupt you. I was just going to say, it sounds very much like in the U.S. I've actually never had an economist who's asked me to give them less data. But please continue.
Yeah. So we will always ask for more data, and we will ask for all that there is. And one of the reasons for that focus on the data side is because before you do any data analysis, you really do need to understand that data. And one of the things that we do is we sit within my team sits within a litigation practice. So we're surrounded by IT and data experts and also accountants. And that tends to produce the best results, because as the old saying goes, garbage in, garbage out. Before you do any analysis, you really need to pay attention to your data quality.
So Matt, I mean, as John says, we've never encountered an economist who's ever satisfied with the amount of data he has. Just you've litigated or been in front of regulators and courts around the world, not only in the EU. What's your experience of how these judges approach what you as an economist is saying? Are they receptive? Does it depend on the jurisdiction? Do they get frankly confused, or how are courts, who are not always specialist courts, receiving this type of work around the world?
I think there's a little window there to make a joke about economists, because what often happens. Yes, exactly. A joke about economists. The reason for that is because what a court will be faced with is they will be faced with two opposing experts. And a lot of economist jokes are very similar. So why do you want a one-armed economist? And the answer to that, of course, is they can't say on the one hand this, but on the other. So I think one of the things to say, so there's two things to say about appearing before courts and tribunals. The first of those is you need to make sure what you do has a science standard to it. And by that I mean you need to explain your data, your methodology, and your results, and not just the one result that you like, your results as a whole, and why your conclusions are robust, given the overall body of evidence, including any sensitivity analysis that you do. So you do need to, so if you're going to be an expert before a court, a tribunal, or indeed in a settlement meeting, you can't appear to be the magician who pulls out a rabbit out of the hat with no indication of how the rabbit got there, because that is simply incredible, and that's not believable. It's not credible. It's not sensible.
Yeah.
The other thing I think you need to do with courts, tribunals, settlements is you need to be able to explain in plain English what has gone on. So the simpler you can make the explanations you give, the better. You also need to help both sides understand why there are differences of views between experts. And these can arrive due to differences in data, techniques, and assumptions. And then you need to say, in your view, what's the approach you've taken? Why have you taken that approach? And which approach gives you the most robust answer? And I'm going to come back to that data observation very briefly. When you've done all of that, it may well be that you can reach some agreement. Well, actually, the difference that we have between the experts is on this particular data point, and that may be why these pesky economists ask for more data. If there's a particular fact or issue that makes the results different, that's something that needs to be explored further.
Yeah, Matt, that's actually a really good insight. And we talk about magicians. I think the real magic that economists bring is to take something that's really super complicated, where I could use words like, regressions and, collinearity and things like that. Take those really super complicated concepts and magically turn them into simple English words, or whatever language is being used, simple words that a judge who on a daily basis is not dealing with these concepts will totally understand. And you're right. And I talk about a judge. I think I mean, tell me if you disagree with this, but really what you're doing in the settlement agreement is you're trying to get each side to think about, if we were to put this in front of a judge, this is how it would all turn out anyway. So the fact that cases are settling, it really doesn't change that. Does it change the way that you do the analysis at all? I wouldn't think so.
No, not at all. I mean, I think it's very important that if you're going to be an expert and you're having a settlement discussion, that you do that to the same standard that you would do before a judge. I'm not seeking to be an advocate for the party. I'm seeking to set out a description of where I've got my data from, the methodology, the assumptions, and so on, and why I've done what I've done. And also, I've never done one of these cases where I simply say the answer is the damages are 17.4% or whatever it may be. I will always say, here are the range of answers. that are plausible and sensible. And in my opinion, it's at this end of the range or that end of the range. And that's the credible thing.
Matt, I think that's an interesting point. You just alluded to the issue of an expert before at least the UK courts. Maybe for our US audience, you could expand on that. The concept of the expert in the at least in the English courts, which is I think a bit different from elsewhere.
Absolutely. So one of the things that if you litigate before the UK courts, the person who pays you is very different from the person who is going to be asking you all the questions and all the rest of it. And that's important because in the UK courts, you are bound by particular sets of rules that require you are an expert for the court. So you have particular duties to the court, including to give the balance of your views and the totality of your views. So you can't privately think this is a great case or tell the client this is a great case, except for this large elephant in the room. You need to be able to deal with the elephant as well.
So it's more difficult to be a hired gun, if you like.
Yes.
Matt, I think you're probably going to say everything in answer to this question, but having done a lot of these cases in the UK and elsewhere around the world, what are the key issues or points of contention that come up between claimants and defendants? I mean, cartels, of course, one type of case, but there are issues in other types of competition claims as well. What would you see as the key points, apart from everything?
I think that is a very I think that varies very much on a case-by-case basis. So I think I won't say everything because that's not helpful. But to give an example, one of the cases we worked on, one of the issues that we wanted to explore at the outset is what are the key things that will change the outcome on the case. So in the EU, which is a bit different from the US, or at least federal law in the US, is that there is what's called a pass-on defense. So if it's the case that there was a cartel, you're a direct purchaser, but you raised your own prices, it may well be that in response to that cartel, it may well be your profits didn't particularly suffer, and it may well be that your damage award was low or possibly very low indeed. So we were doing a case recently which involved the wholesale of a product that was purchased in and then simply resold. So a factual question that we needed to understand is even if the cartel had been very effective, is it the case that my client would have suffered no real harm? So what we looked at in that case is we found that, contrary to perhaps my initial prejudice, I thought there might be a very high degree of pass-on. What we actually found is this product was actually one that was sold with a range of other products. And actually, if you looked at the cost price of this cartelized product and its wholesale price, there was actually no relationship at all between the cost price of this product and what it was resold at the wholesale level. So contrary to my initial expectation, pass-on was very low indeed, and that suggested that case was worth pursuing. And we've had various settlements following that discussion. We then did the damages analysis as to what the overcharge was and so on. But we needed to get that key point out of the way. So I think the answer is, on a number of these cases, there is often some points that you need to explore at the beginning that do make a real difference, the outcome, but they vary a lot on a case-by-case basis.
As you say, a key issue here in the UK and elsewhere in the EU is pass-on. The flip side of that is indirect purchasers are also able to bring immediate claims, aren't they? If they can prove loss, then they can bring a claim for that loss.
Yes, a good example of that. Sorry, I was interrupting you, John.
No, I was going to say that in the U.S. we have the benefit of getting to pay twice or three times if you're a defendant, because you get to pay full freight on the direct purchasers where there's no pass-on defense, and then if there are indirect purchasers, they get paid too. And not surprisingly, in virtually every case I'm in, we hear from the direct purchasers that there's no pass-through, and from the indirect purchasers we hear that there's greater than 100% pass-through. So, that's not to criticize. I think in some ways that suggests the system in Europe, it may be more efficient because defendants basically pay once.
I think that's what should happen. I think what does happen is a bit more complicated than that. But I think it's an issue that, as a point, we need to make sure, from a policy perspective, I think we need to make sure that is properly managed so that people there aren't multiple claims. So, for example, and I shall choose my word carefully now, for example, there's a case involving interchange fees, which are the fees relating to usage of credit cards, particularly MasterCard and Visa, which are the subject of extensive litigation. And one of the complexities in that case is precisely what you just said, John, which is the retailers are claiming damages. And there's also a collective action for damages which is being brought aimed at giving consumers benefits. And what one would hope is that there's some coordination around all of that, so that there isn't excessive payouts relative to the actual harm. But we'll have to wait and see how that plays out.
That's right. Matt, I wanted to raise, shifting gear a bit here. We mentioned at the beginning that there has now been an award by a judge of damages in the UK in a follow-on case. So that was very big news here, and also as a precedent for elsewhere. Do you want to make some comments about the BritNed case? Also, it'd be helpful if you could also mention, some of the comments that the judge had about the differing economic analyses in that case.
Sure. So perhaps a good thing to say first is that this case has been appealed by both sides. So we'll have to wait and see how it all ends up. But by way of background, what it related to was a single undersea power cable project, which was called BritNed. And the European Commission had found that this had been specifically allocated by the cartels to one of their members, ABB. So there was it was very clear that this project had been cartelized. So that was the starting point. And therefore, a key issue that needed to be explored was whether this BritNed undersea power cable system was more expensive than otherwise would have been the case. And the judge emphasized that was the key question. Not whether ABB might have provided a little lower price if it hadn't been a cartel, but whether the price that would end up being paid might have been less. So one of the problems with the claimants' econometrics model was that what they sought to do was they sought to answer a different question, which was namely whether ABB's prices were higher on average during the cartel period. And that was a problematic approach because there were reasons for believing the BritNed project was not typical of the overall body of ABB projects. And that was because there was clear witness evidence, which the judge gave much weight, that those at ABB who had negotiated prices on that project were completely unaware of the existence of the cartel. BritNed itself also negotiated very hard for that, for the prices, and it didn't need to proceed with this project. So one of the problems that the judge had with modelling that was done is it wasn't answering the right question because it was answering on average were prices higher rather than whether this project was higher. And in those circumstances, the judge gave a lot of weight to much simpler evidence, which showed that profit margins, ABB's profit margins on this project were actually somewhat lower than average, even relative to post-cartel or similar, or even relative to post-cartel prices.
So, Matt, I think that shows that even where you have very clever economists producing models, there's still a role for the lawyers there to make them step back and think, and not to mention the businessmen, is this reality and is this going to stand up to an independent judge? Can you, I think, just if you can leave us here, Matt, we've talked a lot about these cases, we've even been on the same side. Do you have any lessons for companies and advisors who are contemplating either defending or bringing any of these claims? Are there some 2 or 3 kind of key messages that you could leave with us?
Absolutely. I'm going to close with yet another Economist joke, which is, what do econometricians or what do econometrics and sausages have in common? And the answer to that is no one wants to see how they're made. So my experience, Matthew, is that good lawyers ask questions. Great lawyers really get into the detail of the route map that both their expert and the other expert has gone through to pull up this material. And I think that the first lesson is the lawyers really need to understand that whichever expert they appoint or the opposing expert, what precisely have they done and why have they taken that approach and how sensitive are the results of that approach. I would also emphasize, as at the beginning of this conversation, that data is absolutely king in these cases. And if your data is not of the highest standard, and that's why economists always want more data, you may have discovered that you built something very beautiful, but it's a house of cards built on sand. And one small wave will knock it over. And the great lawyers, and you've done a very good job on this in some cases, Matthew, I know, but good lawyers and great lawyers are very good at spotting what that one wave is that will knock the house of cards over. And I gave the example of it in Europe, for example. It could be a pass-on question, or it could be a range of things. But often there's a small number of points that make a big difference to the overall conclusions you reach.
Matt, this has been really helpful. And I think for years here in the U.S., we heard about private damages litigation, and we said, well, it's coming, but it took a while to develop, I think, just for a variety of reasons. I think what I'm seeing today, and I'd be interested in your thoughts on this, I think it's here, and I think it's here to stay, and I think it is something that global companies have to take very, very seriously.
Absolutely. I mean, as far as I'm aware, cartel damages cases, as Matthew said at the beginning of this call, are brought in every single case. There was a cartel involving canned mushrooms, which are not a very pleasant product, and I don't think damages were sought there. But I think almost every case will have cartel damages action sought now, if the market's sufficiently big. So I think it is a clear fact and reality, and litigation, as the two of you know better than me, you really need to prepare and do your homework for, both to deal with people trying things on, and also to make sure that you're well prepared to think about, should I settle now, should I litigate, and all of these difficult questions.
Yeah, there's nothing like fungus in a can. I want to just maybe shift gears a little bit. Matt, since we've been on, you've told at least 3 economist jokes. I think it's probably fairly clear to our audience that you really enjoy being an economist. Tell us, why do you like that? What's fun?
I think what I particularly enjoyed about it is because, and why I'm lucky to have the job that I have, is that it really makes you think and it makes you put you through your paces. And there's a lot of variety. I also get to work with people who are not economists, so lawyers and data experts and accountants and industry experts. And I think that pulling together of a cohesive story about what's going on and what the reality is, I really enjoy doing that. And I also enjoy thinking about how to translate some very technical subjects into things that resonate properly with business people and lawyers and judges, because there's an art to that, and that's fun to do too.
And Matt, if you could give advice to the 25-year-old you about, what to do in your career, what would you tell yourself?
To the 25-year-old me, I would say very well done for starting your career at the UK Competition Authority. They were very patient with me. They taught me a lot. It was a great learning ground, and I'd really recommend that to people starting their career. So thank you to the Office of Fair Trading who kindly hired me. I would also say, be curious and don't be afraid to ask questions, particularly when you don't understand things. I often go to meetings and I think, I'm not really following this. And often there's a reason I'm not really following it, and it's because it doesn't have a proper evidence base, or it's a sort of groupthink that people have got together. This is not to criticize them, but I think often in litigation and arguing and things like this, the trick is to tease out where the points aren't as robust as they could be. So don't be afraid to ask questions and be critical.
All right, Matt, one more from me. We haven't met before, but tell me something that's unusual or surprising about yourself that if people who've known you professionally for a long time may not know. So
people who know me professionally probably get the impression that I've eaten too many biscuits in these client meetings over the years, and that's certainly true. But I'm also a very keen cyclist. So if you live in south of London, you will often see, at the weekend at least, for several hours, you'll see a man, unfortunately wearing lycra, on a bright orange mountain bike or racing bike, trying to sort of go up hills. So that's something I do in my spare time. So which I enjoy very much.
Well, Matt, thank you. We have one more segment in our show that we call the Curious Hat.
And now it's time for the Curious Hat.
So, Matt, this is the time in our show where we have a hat full of questions, and you choose a question and we ask it. So, I would ask you to choose a number from 1 to 20, and I will pull that card out of the hat for you.
Can I have question 1, please?
Question number 1. Okay, question 1. Matt, what are you currently reading or hope to read next?
So I'm just nearly finishing a book called Search Inside Yourself, and unlike the sort of John Grisham type stuff which I normally read, it's actually about emotional intelligence. And one of the reasons I was interested in reading all of this is, apart from some desire to be a better person, is sort of a lot of the things that I do for a living are actually about interacting and arguing with other people. And I think I had a sense that I needed to sort of raise my game in that area and sort of pay a lot more closer attention to some of the cues and signals they're giving me, and also generally how to progress things. So I was interested in reading something different from my usual set of reading material.
And Matt, one more question. Is there anything that you've read recently that if, kind of your literature professor from college ran into you would deny having read?
That's a very difficult question. I probably would have to apologize for all the rubbish science fiction that I've read over the years, which I think are probably written by a computer these days. So I think it will be the science. It's the pulp science fiction that I've been reading. I think that will probably be high up on my list.
Well, Matt, thank you. I wish we had more time for Economist jokes, but I think we're out of time. Thank you for joining us.
Yeah, there's a lot of them for next time.
So we'll have you back for a podcast on Economist jokes. Until then, thanks for listening, and we'll see you next week on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.org. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.